Most folks, when you think about Supreme Court cases involving the Second Amendment, think of the case of Heller and McDonald. But are you familiar with an equally important case, a 2016 case called Caetano versus Massachusetts? You better be. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, and proud American gun owner. If you haven't subscribed to this channel, please do so. We really would appreciate it. I want you to understand today a case by the United States Supreme Court called Caetano versus Massachusetts. Caetano versus Massachusetts. It's very important that you, in order to be smart on the Second Amendment, understand this case in addition to Heller versus D.C. and McDonald versus Chicago. You see, Caetano versus Massachusetts is going to be very important to your rights in two ways. First of all, it's going to help provide the basis for defending and protecting your right to bear AR-15s against bans, which the anti-gunners have done in certain jurisdictions and they like to do in others. Caetano versus Massachusetts is also going to be very important in the NYSERPA versus Bruin case that's going to say, in my view, that you have a right to carry guns outside the home in public for self-defense. They're going to extend the rights of the Second Amendment outside the home, which, of course, as you know, Heller and McDonald were two cases that say you have a right to a loaded gun unlocked in your home, and states cannot prevent that. But the Bruin case, or NYSERPA versus Bruin, is about extending those rights outside the home and interpreting the phrase the right to bear arms as opposed to the right to keep arms. When you think about Supreme Court cases involving the Second Amendment, you probably think of the Heller case, which in 2008 said you had a right to a loaded gun in the home for self-defense, and McDonald, which said the same thing in that states and localities cannot ban you. But I want to talk about this 2016 case of Caetano versus Massachusetts. You see, Caetano versus Massachusetts is a case involving a woman that used a stun gun outside the home to protect herself against an ex-boyfriend. That's what was alleged. Of course, the Commonwealth of Massachusetts banned stun guns because it's Massachusetts. And what does Massachusetts think about firearms or all guns? Well, we know what they think.
Guns are not the answer.
She was arrested and convicted of the illegal possession of a stun gun. She asserted that she had a Second Amendment right to possess this stun gun because it was an arm protected by the Second Amendment's right to keep and bear arms. And the state of Massachusetts all the way up said, no, we don't agree, because you know what the Massachusetts people think. Or I should say, let me be clear, we know what the Massachusetts government and the legislature thinks.
Guns are not the answer.
That's right. So in the Caetano case, she asserts her Second Amendment right. The whole system in Massachusetts rejects her arguments. She goes to the Supreme Court, and guess what happens? Right after the death of Antonin Scalia, the U.S. Supreme Court issued the decision in Caetano versus Massachusetts that said that stun guns are protected arms under the Second Amendment. Why is that? It's because they were commonly possessed by Americans for lawful purposes, to the tune of somewhere between 100 and 200,000 people own stun guns in the United States and possess these. That's what the Supreme Court said in a concurrence by Samuel Alito, who you probably have heard a lot about just recently. Now, the reason why I think this case is so important, and you need to put Caetano on your list of cases to know, in addition to Heller and McDonald, is because Caetano stands for two critical propositions that will protect your rights going forward, as I see it. The first is that it's going to help you protect your AR-15. Why is that? Because the Supreme Court said that it doesn't matter if a firearm or a weapon existed at the time of the founding. All that matters is that today, Americans commonly or typically possess these things for lawful purposes, and then they're protected arms. Because stun guns, according to the Supreme Court, were protected arms, they were commonly possessed, they're protected arms by the principles of what's called a fortiori, which means if it's true for the lesser, it's true for the greater. Guess what? I would think AR-15s will be protected because under Caetano, stun guns are protected. There's a lot more AR-15s out there than stun guns, so obviously AR-15 should be protected against any kind of gun ban. So that's what Caetano versus Massachusetts stands for first. The second reason why Caetano is very important to your rights is it's going to be a very helpful case when the Supreme Court decides, in my opinion, that you have a right to bear arms outside the home, that you have a right to carry guns outside of the home. Why is that? And by the way, that's the case, of course, of NYSERPA versus Bruin, which you've talked about on this channel and you've heard a lot about, and you're anticipating the decision in June. The reason why Caetano is important for this is because, remember, this was a court that did not have Antonin Scalia. He had just passed away, but it had Ruth Bader Ginsburg on it, right? So here's what's interesting. Where did Miss Caetano use her stun gun? according to the case, Ms. Caetano used her stun gun outside in public. So this is critically important because if the Supreme Court was not going to say that the right to bear arms extends outside of the home, then why did they basically let Ms. Caetano off the hook on the grounds that it was a violation of her Second Amendment rights to deny the right to use a stun gun because she used the stun gun in public? That's where she had it, and that's where she used it. So again, it's strongly indicative that the Supreme Court is going to, in Nysurpa versus Bruin, find that you have a right to carry guns outside the home in public for self-defense. Okay, bottom line is, as we wrap up, 3 cases you need to know about to be smart about the Second Amendment. Heller versus the District of Columbia, you have a right to a loaded handgun in the home. McDonald versus Chicago, you have a right to a loaded handgun in the home, and states and localities can't ban it. Heller was about the federal government. McDonald was about states and localities not banning handguns. And Caetano versus Massachusetts says you have a right to a stun gun because it's commonly possessed by Americans. And if stun guns are commonly possessed by Americans, guess what? AR-15s are possessed in much greater numbers than anyone who owns stun guns in the United States. So if stun guns are protected in the United States by the Supreme Court under the Second Amendment, so too will AR-15s. Okay, well, I hope you learned something here today, and we'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.